Yes, ma'am. Ready to go, ma'am?
Yes, sir.
Okay.
So you had your lunch properly, or
Lunch is 1 hour away. I, I,
okay?
I have an office running in the other three rooms.
Oh, all right. I think it's been very long for you speaking for 3 continuous hours.
See, as a lawyer, you get used to this
Correct.
because, and you are, here you have the privilege of sitting down.
Hmm.
Otherwise, standing. The expression or the phrase, um, "I am on my legs." When you
Yes.
have to ask for an adjournment, it means that I am standing and arguing. Now, of course, you have the privilege of sitting in your track pants, sitting down. I
Uh,
like your smile; it is very infectious.
Thank you so much, sir. Thank you. So, at the cost of repetition, sir, but I think it's very important for the students to know of your achievements, and so I would like to just take 2 3 minutes.
Yes, please.
Very good afternoon to everyone, and I believe it's a great privilege for all of us to be taught by the likes of Advocate Anil Malhotra, sir. And although describing Sir's career, which is filled with accomplishments, in just a matter of few minutes, is not correct as per my opinion. But I will try my best to give you the gist. So, Sir has been practicing advocate in India since 1983, and his educational qualifications boast of extremely reputed institutions. He did his Bachelor of Science and Bachelor of Laws from Punjab University, Chandigarh. Thereafter, he went to University of London for his Masters in Law. And thereafter, he also studied comparative family law at London School of Economics, along with another course on law and society at School of Oriental and African Studies. Both the institutions in itself speak about their repute. So, at professional level, Sir has conducted matters in Indian courts relating to divorce, custody, maintenance, and other adoption and property related issues. And his contribution anent these issues of intercountry adoptions and interparental child removal issues and also surrogacy, it has been extremely significant. For over 35 years, Sir has also acted as an Indian expert to render reports in foreign courts on appointment by the bench in overseas jurisdictions. So his accolades at the international level are remarkably inspiring as well. He was also elected as the fellow of the International Academy of Family Lawyers, London, and he was also nominated in 2010 as the India member of the International Family Law Committee of the International Association. And to add more feathers to his towering cap, his teaching career has been inspiring a lot of people from the law fraternity. He has co-authored many books and has written and has published works in both international as well as domestic sphere. And when it comes to the Symbiosis family, his teaching prowess is well known to us, and that is another reason we always look up to him to come and enlighten our students in the best way that he teaches here. So, sir, you may please start with the
Thank you
lecture.
very much for the wonderful introduction. So nice of you for the warm words. Friends, a very good afternoon to you. Today we talk of children, child custody laws, and what is the position in India. Now, a child under all Indian legislations is known as a minor person of under 18 years of age. But factually speaking, not legally speaking, a child is the father of man. A child is a person who influences your life, influences society, is the most stable bedrock of the home, and makes and breaks families because of child custody issues and when particularly when there are ugly disputes. Now, just to give you a broad scenario of how we are in terms of laws concerning children and the family. You all know we are a multicultural society. Uh, we do not have a uniform civil code under Article 44 of the Constitution of India, which is a directive principle of state policy. We are supposed to have a uniform civil law, which means we are supposed to have a unified family law. But other than the state of Goa, which follows a Portuguese code, we do not have any family law which applies universally throughout the territory of India. And the reason for this is that we have Hindus, we have Muslims, we have Christians, we have Parsis, we have Jews, amongst other communities living in India. All these communities live in 29 states and 8 union territories over a territory of 3.28 million square kilometers. And each of these communities, Hindus primarily, have their own acts of law made by Parliament. The some of them are very old. The Parsi Marriage and Divorce Act is of 1936. The Guardian and Wards Act is of 1890. The Divorce Act was of 1869. It has been amended recently. But the fact remains that these laws exist and they are enforced as they are. We have some secular provisions like Section 125 of the Criminal Procedure Code, which applies to all. We have the Protection of Women Against Domestic Violence Act 2005, which applies to all. We have the Juvenile Justice Care and Protection of Children Act 2015, which applies to all religious communities, and the Family Courts Act, which enforces most of these, which is also applicable to all communities. But the fact remains that marriage, divorce, adoption, custody is still regulated by personal laws. Now, it is in that perspective that the Hindu Minority and Guardianship Act of 1956 is the law relating to minority and guardianship among Hindus. I may also share that we also have the Guardian and Wards Act of 1890, which was made by the British 145 years ago, and which decides how a court petition for guardianship and custody is to be dealt with. Because the Hindu Minority and Guardianship Act only gives the right to a Hindu. The statutory process is governed by the Guardian and Wards Act, because the form of the petition, the way the petition is to be filed, and the way the content of the petition is to be described, etc., and the right to go to court are under the Guardian and Wards Act. So with this introduction, we come to what the Hindu Minority and Guardianship Act reads. Now, the Hindu Minority and Guardianship Act in the very beginning in section 3 says, the provisions of this act are in addition to and not in derogation of the Guardian and Wards Act. So there it is. It's very clear in the beginning only that the HMGA is only going to give you the right as a Hindu, whereas your right for any other purposes will be what Guardian and Wards Act says, because this is a supplementing legislation. So as I told you, it applies to all persons who are Hindus, and if you are a Buddhist, Jain, or Sikh by religion, you will be a Hindu. Section 4 defines who is a guardian. So who is a guardian? A guardian means a person that is a natural guardian, a guardian appointed by the will of a father or mother, or a guardian appointed by the court. So if you are a guardian as a parent, you cannot be displaced, and the only way you can be displaced is if you are unfit. That being so, section 6 says the natural guardian of a Hindu minor shall be the father, and after him the mother. Now, in Geeta Hariharan's case, this discrimination of before after has been done away with. It is ambiguous in its wording, So the Supreme Court says they are both equal. It really doesn't matter who is uh, uh, who. They are both equal. There is no superior or inferior guardian. But it does say that provided that the custody of a minor who has not completed the age of 5 years shall ordinarily be with the mother. So ordinarily, so it is not compulsorily. So there is some kind of a tender years rule, means a gender preference, a maternal preference. Child is very small, mother. So this is the leaning given. But is this right an absolute right? Is a child less than 5 years of age? Is it a must for the child to go to the mother? Can a child more than 5 years of age be with the mother? The answer is yes. It is not necessary that a child of more than 5 years of age should be go to the father. This is not the rule. Likewise, if a child is less than 5 years, child can go to father. I'll explain this in a little point of time. So then section 6 says that a person cannot act as a natural guardian if he renounces the world or ceases to be a Hindu. Then the powers of the natural guardian are in section 8. And then we move to section 13. Now, section 13 it says that in the appointment of the or declaration of any person as the guardian of the minor, the court, by the court, the welfare of the minor shall be the paramount consideration. And it further says that no person will be entitled to guardianship by virtue of the provisions of this act or by any law related to guardianship if the court of the opinion that his or her guardianship will not be fair for the welfare of the minor. So therefore, now coming back to section 6. So ordinarily, the custody of a child less than 5 years shall be with the mother. More than 5 years shall be with the father. But this is subject to what section 13 says. So section 13 by saying no person shall be entitled to the guardianship or custody, that may be interpreted on the basis of a right, and if it is not for the welfare of the minor. So your right is not an absolute right. It is a right in discretion for the welfare of the minor, and you cannot claim that the custody should go to the mother or the father in as many words in such a situation. Now, we have already seen that it should be welfare. Now, the question is, where is welfare defined? Where is best interest enumerated? Now, the answer to this question is in very different terms. Now, we did not have any law or legislation in which this definition was given. Now, I must also fill you in that the rights of children are identified in an international perspective in a convention called the United Nations Convention on the Rights of the Child. Now, this was adopted by the General Assembly of the United Nations on 20th of November 1989, and on 11th of December 1992, it was acceded, or it was accepted, or it was signed by India. So whenever a country accedes or signs an international convention, it has to adopt the provisions of the convention by saying that we are making a law and this law will follow all what is said in the convention. But you can also say that we are making our internal law, and you may provide independent statutory provisions in your law for adopting whatever you want to highlight from the convention. So in the convention, there are the rights of a child, right to life, right to family, right to a home, right to custody of both parents. So all these rights had to be crystallized, and India decided to make different laws to protect the rights of children. Protection of Children Against Sexual Offences Act, Right to Compulsory Education Act, Commission for Protection of Child Rights Act are some of the enactments which India enacted. Now, we also thought that we should incorporate the definition of the best interest of the child in some law. So we had the Juvenile Justice Act of 1986. It became the Juvenile Justice Act of 2010. And ultimately, in 2015, we amended and we called it the Juvenile Justice Care and Protection of Children Act 2015. For short, the JJ Act. Now, JJ Act deals with three things. It deals with children in conflict with law, children in need of care and protection, and children who need rehabilitation, integration, and adoption. So we are, when dealing with custodial disputes of interparental child custody, we are talking of children in need of care and protection. Now, in this context, the definition of best interest of the child, copied from various beneficial provisions of the Convention on the Rights of the Child, the UNCRC, in section 2, subsection 9, we defined the best interest of the child to say best interest of the child means the basis for any decision taken regarding the child to ensure fulfillment of his basic rights and needs, identity, social well-being, and physical, emotional, and intellectual development. So we picked up the definition of the best interest of the child from various components of the UNCRC, and we put it in the JJ Act. Now, this definition was not noticed in interparental child custody disputes for a long time. I urged this point before the Delhi High Court in a number of petitions, and ultimately, in three matters, it was noticed, and it was said that this definition will apply to children in need of care and protection also. It is not only for children in conflict with law, because a child whose rights have been violated by another parent is a child who needs care and protection. And in the context of custodial rights, this judgment, this definition was first noticed by the Supreme Court in the decision in Lahari Sakhamuri's case, because it was agitated that this is a right which needs to be expounded in the context of the welfare of the child. And therefore, in Lahari Sakhamuri, in 2019, the Supreme Court, while deciding the rights of whether a minor less than 5 years of age should be with the mother or not, was answered in para 43 by saying the expression best interest of child, which is always to be kept in mind to be of paramount consideration, is indeed wide in its connotation, and it cannot remain the love and care of the primary caregiver, i.e., the mother, in the case of an infant or the child who is only a few years old. So, very clearly, the Supreme Court is saying child is less than 5 years of age, it cannot remain the love and care of the primary caregiver. So, there can be a custodial issue where a child less than 5 years of age can be with the father. So, the Supreme Court further says the definition of best interest of the child, as envisaged in Section 2(9) of the JJ Act, means the basis for any decision regarding the child to ensure the fulfillment of his basic rights and needs, identity, social well-being, and physical, emotional, and intellectual development. So the Supreme Court, noticing this definition, has very clearly spelled out that the love and care of the primary caregiver can mean that a child less than 5 years of age will not be necessarily be with the mother. Now, the same thought process was further developed by the Supreme Court in Vasudha Sethi. This is Kiran Bhaskar, a decision of the Supreme Court of 12th of January 2022. Now, this decision arose from a judgment of the High Court of Punjab and Haryana. I happened to assist the High Court as an amicus curiae. And this was a dispute between the mother and the father over the custody of the child who had been brought by the mother to India for medical treatment, but the mother declined to go back to the US after the treatment was over. The father filed a writ of habeas corpus. The child was ordered to be returned to the US. The mother appealed to Supreme Court. The Supreme Court affirmed the decision of the High Court. Now, before I go further, let me explain to you what is the writ of habeas corpus and what is the difference between the custody issue in a writ of habeas corpus and the custody issue in a Guardian and Wards Act petition. Now, technically and legally, we have not identified interparental child removal as a wrong. So if one parent removes a child from the custody of another parent, it cannot be called kidnapping. If a child is removed from the custody of a parent by relatives also, it may not amount to kidnapping. Legally, it is looked at as removal. Wrongful retention or removal is looked at in the Hague Convention on Civil Aspects of International Child Abduction 1980. It is signed by 100 countries abroad, but India is not a signatory because India does not agree with the concept of wrongful removal or retention of a child by a parent. So having said so, we do not have any law under which child removal is identified as a wrong or an offense either under civil or criminal law. So therefore, whenever a child is brought from a foreign country or even moved from the custody of one parent to another, you often find that a parent moves the writ of habeas corpus under Article 226 of the Constitution of India in the High Court or under Article 32 of the Supreme Court before the Supreme Court of India in a prerogative extraordinary remedy. Now, this is a very special power of the High Court and the Supreme Court under the Constitution. The courts also have appellate powers, but this is an extraordinary jurisdiction where the court has very vast powers. Obviously, they are circumscribed by precedents of law, but in a writ of habeas corpus, normally it is used to get a person in illegal confinement. But where children are concerned, it is used or it is relied upon when the welfare of the child is at stake. We follow English and American law on this perspective. And in Gohar Begum in 1960, the Supreme Court used it for the first time. So in a writ of habeas corpus, if child is removed from a foreign jurisdiction, a writ of habeas can be used for recovery of a child and for return back to the foreign country on the basis of a foreign court order. Now, it is in this context that the Supreme Court in Vasudha Sethi on 12th of January 2022, expounding the concept, said, the principle that the welfare of the minor shall be the predominant consideration and that the rights of parties to a custody dispute are irrelevant has been consistently followed by this court. In fact, under Section 13(1) of the HMGA, it is provided that in the appointment or declaration of a guardian of a minor, the welfare of the minor shall be the paramount consideration. When a court decides that it is in the best interest of the minor to remain in the custody of one of the parents, the rights of the other parent are bound to be affected. As provided in Section 6A of the 56 Act, which I read out to you, in the case of a minor boy or girl, natural guardian is the father, but ordinarily the custody of a minor who has not completed the age of 5 years shall be with the mother. Now, this is the key word. On a conjoint reading of Section 13(1) read with Section 6A of the 1956 Act, if it is found that the welfare of a minor whose age is more than 5 years requires that his custody should be with the mother, the court is bound to do so. In the same way, if interest of the minor, which is the paramount consideration, requires that the custody of a minor child should not be with the mother, the court will be justified in disturbing the custody of a minor who is less than 5 years old. So There is no vested right. Age is just a number. If the child is less than 5 years of age, custody can be with the father. If child is more than 5 years of age, custody can be with the mother. So, what is the determining factor? The determining factor is, in this case or such cases, rights of father or mother are bound to be affected. Whenever the court disturbs the custody, the other parent will have visitation rights. The order for visitation will be for the welfare of the minor. And then they say, we cannot accept the submission that while applying the welfare principle, rights of parents need to be protected. The consideration of well-being and welfare of the child must get precedence over the individual or personal rights of the parents. So, bottom line is that ordinarily is not mandatorily. So, less than 5 years, custody can go to father. More than 5 years, custody can go to mother. What is the crunch? What is the determining factor? Determining factor is welfare. So, the welfare of the child determines this proposition. And when we go further to section 13, the welfare of the minor being the paramount consideration, it is said, in the appointment or declaration of the guardian, the welfare of the minor shall be the paramount consideration. And it says, no person shall be entitled to guardianship by virtue of the fact, by provision of this act or any other law in marriage among Hindus, if the court is of opinion, the guardianship will not be for the welfare of the minor. So, welfare overrules precedence by virtue of parental rights and is subordinate to it. So, this is the key crunch in this. Powers of a natural guardian are under section 8. And with this, we now move to what is written down or what is said in sections of the Guardian and Wards Act. Now, as I said to you, the Guardian and Wards Act is the law under which the petition is to be filed. The right comes from the Hindu Minority and Guardianship Act, and the right to file, the way it is to be filed is under the Guardian and Wards Act. So, section 7 of the Act says, where the court is satisfied that it is for the welfare of the minor, it can appoint a guardian and declare a person to be a guardian. And who is entitled to apply? It is a person claiming to be the guardian, it is the relative or friend or the collector. Now, sections 8, 7 and 8 are subject to section 19 because section 19 says guardian not to be appointed by the court in certain cases. Now, if there is a minor whose father and mother is alive, unless and until the father or the mother is unfit, the guardian under section 7 and 8 cannot be appointed. So the onus is on the person seeking appointment as a guardian to be displaced before he can be appointed, unless and until the unfitness comes. Then we come to section 9. Section 9 talks of the place where the petition is to be filed for guardianship. Now, the rule is, if the application is with respect to guardianship of the person of the minor, it shall be made to the district court having jurisdiction in the place where the minor ordinarily resides. Now, where is the minor living is a matter of fact, and it is to be determined by the residence of the minor. So, if the minor is born in a foreign country, is going to school in a foreign country, the matrimonial home of the parties is in a foreign country, or maybe within India in a different place, but the mother has moved or the father has moved to a separate place, the ordinary residence of the child will be where the child lived, not where the mother is living on the date of the filing of the petition, because under section 9 of the Guardian and Wards Act, the residence of the child and not the residence of the mother is the crunch. So, a argument that under section 6 of the HMGA, the residence of the mother is the residence of the child cannot be accepted, because under section 9, the jurisdiction is determined by the Guardian and Wards Act and not the Hindu Minority and Guardianship Act. And this, in as many words, has been said very clearly in Tejaswini God in 2019 by the Supreme Court, because the Supreme Court here says in para 20, in cases arising out of the proceeding under the Guardian and Wards Act, the jurisdiction of the court is determined by whether the minor ordinarily resides within the area on which the court exercises such jurisdiction. So it is the determining factor of jurisdiction decided on the basis of where the child resides, which is to be considered to be the paramount consideration. So, not where the child is living when the petition is filed, not where the child is brought forcibly. And this is a well described phenomenon occurring now and was identified by the decision of the Supreme Court in 2011 in Ruchi Maju's case. Now, in Ruchi Maju, there was a dispute between parents living in Canada who had relocated to Delhi with the consent of the father. The father sought to file a petition for removing the child back to Canada. The child was in Delhi by the consent of the father. So the Supreme Court in this context went into the matter and said, in cases arising out of the proceeding under the Guardian and Wards Act, the jurisdiction of the court is determined by whether the minor ordinarily resides within the area on which the court exercises jurisdiction. There is thus a significant difference between the jurisdictional facts relevant to the exercise of powers by a writ court on the one hand and a court under the Guardian and Wards Act under the other. I just told you, in a writ court under 226 or 32, the power is vast, but the power under the Guardian and Wards Act is little because it can only be exercised within the limited territory or jurisdiction within which the court holds a power. So, if there is a town or a city, the guardian judge in that town or city will exercise jurisdiction within that area only. Unlike the High Court, which may exercise jurisdiction, though within the state, anywhere within the state, but in very different terms. So it further says, having said that, we must make it clear that no matter a court is exercising powers under the Guardian Wards Act, it can choose to hold a summary inquiry into the matter and pass appropriate orders, provided it is otherwise competent to entertain a petition for custody under Section 9 of the Act. So only if a child lives within the territory of the court can the guardian judge make an inquiry. If the guardian judge finds that the child does not live in his territory where he exercises jurisdiction, the court cannot exercise jurisdiction. So therefore, the Supreme Court says in para 62, it does not require much persuasion for us to hold that the issue whether the court should exercise or hold a summary or detailed inquiry would arise only if the court finds that it has jurisdiction to entertain the matter. If the answer to the question touching the jurisdiction is in the negative, then the logical conclusion has to be an order of dismissal of the proceedings or return of the petition to be presentation before the court. A court that has, now this is the crunch, a court that has no jurisdiction to entertain a petition for custody cannot pass any order or issue any direction for the return of the child to the country from where he or she had been removed, no matter such removal is found to be in violation of an order issued by a court in that country. So if the guardian judge finds that the child is not living in, ordinarily residing in the territory where the court is exercising jurisdiction, court cannot do anything. What is the remedy? The party aggrieved by such a removal has to seek any other remedy legally open to it, but no redressal is to be made to such a party within permissible limit before the court, which find it has no jurisdiction to entertain the proceedings. So if there is no jurisdiction, then the court cannot do anything. A writ court, however, can do a lot, but the powers of the statute circumscribe the limits of jurisdiction for the Guardian and Wards Act. So coming back to the Guardian and Wards Act, now Section 10 defines what is the content of application of a Guardian and Wards Act case. Section 11 defines what is the procedure to be followed. And Section 12 talks about making interim orders or orders during the pendency of the petition when a matter is taken up, and it says power to make interlocutory orders of protection of minor and protection of the property or person of the minor. The court may direct that the person, if any, having the custody of the minor shall produce him or cause him to be produced at such place. It may make such order for temporary custody and protection of the person or property of the minor as it thinks fit. Now, the word such order and temporary custody have very vast connotations. It depends on how the court looks at it. Now, does word such order mean single custody? Does word such order mean joint custody, shared custody? Does such order and temporary custody mean a joint or a shared parenting plan? Now, these are interpretations which a judge is free to develop, and there is no, so to say, rule that single custody should be awarded, because welfare of the minor is the crunch. If the judge thinks it is for the welfare of the minor, he can do joint custody, shared custody, and so on and so forth. Now, again, what is the barometer? What is the characteristic to determine this is in section 17. In appointing or declaring the guardian of a minor, the court shall, subject to the provisions of this section, be guided by what consistently with the law to which the minor is subject appears in the circumstances to be for the welfare of the minor. So, what is the word such order to mean? What is the temporary custody to mean? Is something to be decided on the welfare of the minor. So, there is no rule that custody should be single custody. The welfare of the minor is to be decided. If the judge thinks no, child needs to be both with father and mother, the judge can make a joint custody order, and so on and so forth. And section 17.3 also says if the minor is old enough to form an intelligent preference, the court will consider as the wishes of the child also. Section 19 I have already read to you, and section 25 reads with the welfare of the minor to be returned to the custody if the child is removed from a custody. Section 26 says that when the petition is pending, the child will not be taken away from the jurisdiction of the court. Now, with these two enactments, we come to the third enactment, the Family Courts Act, which actually deals with the court or the forum and the procedure under which it is to be dealt with. Now, the Family Courts Act 1984 was introduced to establish family courts with a view to promote conciliation and secure speedy settlement of disputes relating to marriage and family affairs and for matters connected therewith. Now, establishment of family courts is provided for in Section 2. Section 2 says a family court is what is coming under Section 3. Section 3 says wherever the population is exceeding 1 million, the family court can be formed. Now, the process is that the family court is notified by the government and the judge is supplied by the High Court concerned. Then all officers, councillors, other, etc., are to be employees of the family court. Now comes jurisdiction. Now, what are the matters which the family court will deal with? The family court will deal with what is said in Section 7. It says, Section 7 says, all matters, the jurisdiction will be with the court, which was originally the district court. Now, the district court is the court where normally the petitions go. Under the Hindu Marriage Act, they go to the district court. District court means the district judge or his nominee. So the jurisdiction of the district court is with the family court now. For what? For a suit of proceeding for nullity, for declaration of marriage, for suit of proceeding relating to property, for injunction, for legitimacy. Then G, a suit of proceeding in relation to the guardianship of the person or of custody or access to the minor. So guardianship, custody or access case will go to the family court. And Section 8 says that anything to do with the above matters in Section 7 has to go to the family court. So district court will mean all civil courts. and in Bombay, Calcutta, and Delhi, which are original presidency charter courts, where there is original jurisdiction, means power to file civil cases originally. The jurisdiction of the High Court also will merge with the family court in matters concerning Section 7 and under Section 8. And if there is anything pending, Section 8 requires it will be transferred to the family court. Now, we did not have family courts in northern India in most jurisdictions. So, if there is anything which comes by and a family court is notified, it will have to be shifted. If it is filed in the district court, it is not maintainable. It is a bar of jurisdiction. Now, Section 9 says that a family court will make every effort to make a settlement. Now, Section 10 says that the Civil Procedure Code, that is the substantive civil law, and procedural aspects also containing in the orders of the CPC, the procedure to be followed by the court will be the CPC. But Section 10, subsection 3 says, nothing in this subsection shall prevent a family court from laying down its procedure with a view to arrive at a settlement in respect of the subject matter of the proceedings or the truth alleged by one party or denied by the other. So once there is a substantive compliance with procedure under the Guardian and Wards Act, means there is a petition, there is a reply, there is a issues, then the court can devise its own procedure to come to the truth as it so deems fit. And in doing so, Section 14 says a family court may receive as evidence any report, statement, document, information, or matter that may, in the opinion, assist it to deal with effectively in a dispute, whether the same would be otherwise relevant or admissible under the Indian Evidence Act. So there is a flexibility with the court. It can take any document which is relevant or irrelevant, which is admissible or inadmissible under the Indian Evidence Act. All evidence determination is dealt by the Evidence Act. But the family court can depart from the Indian Evidence Act and take in any document, because it is Family Courts Act is meant to settle disputes. It should not go on technicality of procedure, technicality of evidence. It will be free to take in evidence of this nature. So the Supreme Court, the Family Court can record oral evidence under Section 15, or it can it can take formal evidence and affidavits on formal evidence on affidavits. Then proceedings are to be held in camera, though they're mostly held in open. Then Section 12 says, in every suit or proceeding, it shall be open to a family court to secure the services of a medical expert. Of such persons may be related to parties or not, including a person professionally engaged in promoting the welfare of the family, or the court may think fit, assist the family court for discharging its functions. Then the court also says that there is no right of legal representation, but the court can appoint an amicus curiae or a legal expert. So no lawyers are permitted as a rule, but normally speaking, lawyers are permitted to appear on an application. Then a psychologist, a trained counselor, a psychiatrist, anybody can be taken in by the court if the court thinks it is necessary. So orders of family court, final orders are appealable to the High Court, and this is how the procedure is dealt with in the Family Courts Act. Now, the question of how much can a family court depart was raised and agitated in the decided case of Supreme Court in Aman Lohia versus Kiran Lohia, decided on March 17, 2021. Now, this is a very interesting case where a couple living in Delhi had disputes over the custody of a child 3 years old. The father, being unsuccessful in obtaining any interim order from the family court, removed the child from the custody of the mother and via Nepal went away in a clandestine manner to Dubai and converted to Muslim religion. The mother filed a writ of habeas corpus. The father did not appear. Meanwhile, the mother moved an application in the family court in Delhi and got herself transposed as the petitioner. The father was transposed as the respondent. The family court also on the same day gave her final custody in an application under 151 CPC. The husband challenged this in the High Court, and ultimately, when the father did not appear before the Delhi High Court, he was convicted of criminal contempt and kidnapping, and a team of CBI was sent to bring him back. When he came back, the matter was taken up in Supreme Court in appeals. Everything was stayed. The family court appeal was heard by the Supreme Court. I appeared for the father, and it was my urging that the father had done all this very wrongly. But at the same time, the family court could not have diverted from the procedure of substantive law by having a petition. After transposing of the mother, she should have filed a petition, there should have been a notice, there should have been a reply, issues should have been framed, evidence should have been led, and then only the matter ought to have been decided. So my argument before the court was that under the pretext of obviating the requirement of procedure and the court departing from CPC and taking any document as evidence, the court could not have dispensed with the entire substantive provisions of the Guardian and Wards Act. The Supreme Court held, yes, there has to be compliance with principles of natural justice. The father has to be heard. There has to be a petition by the mother after the array of parties was changed. So all this not having been done, the Supreme Court set aside the family court order, and the matter was remanded to the family court to be decided on merits again. Now, in this process, the Supreme Court has also said in Ashish Ranjan that whenever you decide the rights of parties, whenever you decide a child custody issue, the determining question is the paramount concern should be the welfare of the child and not the rights of parties. It says that statutory provision dealing with the custody under any personal law cannot and must not supersede the paramount consideration as to what is conducive for the welfare of the minor, and no statute on the subject can ignore, eschew, or obliterate the vital facts of the welfare of the minor. So, in this context, the Supreme Court also says that a child of small age may not be able to learn family care. The importance of bonding or interpersonal relationships for adequate opportunities. It is necessary that a child should be in regular contact of the non-custodial parent also. Now, the question is, when the child does not maintain a contact with the non-custodial parent, what is the fallout? The fallout, as expressed in Vivek Singh and Romani Singh, is that the child gets polarized or alienated, and the child starts thinking that the non-custodial parent is not available in his life. So this child starts criticizing the non-accessible or non-custodial parent, and this is known as a parental alienation syndrome. To resolve this, you have to provide contact to the other parent. The child has to be counseled, maybe evaluated, and remedies have to be found. And the Supreme Court says till the valuation is done, till this level playing field is not achieved, right should not be decided, because it will lead to a wrong sense of decision. Now, what is the answer to this solution problem? The answer is that there should be joint parenting, there should be shared custody, there should be joint arrangement by consent of parties. And the way I look at it is that the Section 12 of the Guardian and Wards Act talks of such order for temporary custody. Now, these words, if truly to be interpreted for the welfare of the child, means that it is the welfare of the child which is at stake, and therefore, in this situation, in this circumstance, a shared parenting order, a joint custody order ought to be the best option. Now, there are judgments of the High Courts of Karnataka, Savita Sitaram, Tushar Obale, Bombay, JK versus NS, Delhi High Court, and Vasudha Sethi versus Kiran Bhaskar, Punjab and Haryana, where the proposition of a shared custody, joint parenting plan are laid down. Now, it is for a court to see that this parenting plan of shared custody, joint custody should be adopted and taken up. Now, the only exceptions to shared custody, joint parenting could be that when the child is subject to violence, abuse, or grave risk, that this should be done away with. Now, we have not signed the Hague Convention on Child Abduction. Now, in that convention, wrongful removal or retention of a child by a parent means that when a child is taken away by one parent to the detrimental custody of the other, violating the other parent's rights or violating his or her access or rights which are actually in place, that it amounts to wrongful removal or retention. How 100 countries deal with this who have signed the convention is they create a body called a central authority. So from a central authority of one country to a central authority, an application comes of removal. Then within the country, the central authority concerned puts the matter before a domestic court. The domestic court looks at the entire referral matter, and depending on the way it is to be resolved, uh, it provides an answer, and the child goes back to the country from where the child is removed. We have not signed this convention. I was an amicus for 12 long years in a matter where a child was removed to England by an aunt. We could not bring the child back. I gave a report to the court. The report was referred by the court, High Court, to the Government of India. The Government of India sent it to the Law Commission. The Law Commission gave another report, and a committee was constituted. There were 6 honorable judges, 6 administrative officers. I was a lawyer. As a lawyer, was nominated to the committee. We drafted a 2-volume report. We even suggested an inter-country parental child removal bill, where we defined the concept of interparental child removal. The bill suggests that this should be recognized as wrong. We gave this report in 2019, nothing has happened. So bottom line is, our law is largely dependent on how the courts look at it. It is a case-to-case basis determination. Insofar foreign country matters are concerned, they are decided on a case-to-case basis. Sometimes courts send them back, sometimes the court decide them here. But we do have a problem of delay. It takes a long time for a decision to come about, and we have different rungs of appeal. From the family court, it goes to the High Court, then it comes to the Supreme Court. So now this process can take a lot of time. And sometimes in this bitter battle, children get divided. I remember a case of Bombay where the father had the children with him for 2-3 long years, and the children just refused to talk to the mother. So the petition was dismissed. There are also cases where children have been separated, one child with the father, one child with the mother in different countries. So the children are separated, and obviously the children don't want to see their respective parents. So this divides the children, this divides thinking, and this sometimes leads to the breaking up of families also. So this is, in a very large perspective, a bird's eye view of what family law looks like in the issue of child laws. Now, if you have any doubts, questions, queries, any views, any perceptions on how things ought to be or what things are in your mind, please feel free to express.
So this is an extremely interactive batch, so I'm hoping they'll ask questions.
Well, I'm desperately looking for questions. So as usual, you'll have to fire the gun. So,
we do have a student taking lead.
Great, excellent.
Yes, Swarnlata, please.
So we have two students. Great. So, who's first?
Swarnlata, you may ask your question.
Yes, sir. Good morning, sir. Thank you very much for your interactive section. It was very enlightening, sir. Moving on to my doubts, sir. Actually, sir, when it comes to the issue of custody of the child, we find various legal contradictions, because when I see, in case of a child which is a minor or below the age of 5, there are case laws and sections that or precedents which prove that it is good, or in ordinary cases it is good for a minor child to be taken care of the mother. But in a scenario where the mother is getting accused of allegations of adultery, or in a scenario where the mother is not able to properly finance the child, in many precedents, the father takes over the custodianship of the child. I feel there's a huge clash between recognizing what is more important for the child over here. Because is it the financial aspect or the warmth of the mother for a child below the age of 5? So what does because I feel that in the case laws are always weighed down again actually in a 50-50 ratio, because there are some case laws supporting both the issues. So what actually happens in a reality or practical scenario in these cases, sir?
See, the law is very clear. There are precedents that superior financial capacity or better financial resources of the father are no barometer for displacing the cradle and the love of the mother. Very clear. There are 2 or 3 decisions of the Supreme Court on this. But at the same time, there can be very awkward situations. Now, I'll give you a very offbeat and a stray example. There was a North Indian gentleman who moved to England and he fathered 3 children through a prostitute. Now, the woman had a very, very stray life pattern. She was soliciting men, she was on drugs, and she had no control over herself. So, the 3 children in social care were taken in socials by the social services authority in care and relocated till the father's sister in India said the children should be given to her because the mother can't look after the children. Now, this was a case where they had to be taken out of the control or the custody of the mother because they were exposed to all kinds of immoral and wrong activities. But so this is see, whenever you need an answer to a straight situation, you have to go to extreme ends. Now, let's come to the other issue. There is a man with a 6-figure income, but he has only income, he has no time. He has no family member to look after. He has aged parents. So, what is the 6-figure income going to do? The mother may be earning a 5-figure income, enough to sustain the child. So, where should the child go? Obviously, the child should go to the mother because the child needs the mother. Let's examine another situation. There are both parents are earning. One man is work from home. Mother has to go to a job every day. They have a dispute. Father says, I am a sit-home father. This is a very common concept in modern families, though it was a Western concept. But the father says, my mother is living with me. My sister is living with me. I am in a joint family. My sister-in-law is living here. I can look after the child. My earning is less. My wife's earning is more, but she has no time. So this is a factor which has to be weighed through the judicial lens by the by the welfare of the child, I would say. So there is no rule. Supreme Court says less than 5 years can go to father, more than 5 years can go to mother. And very clear, superior financial capacity cannot outweigh the welfare of the child. I hope that answers your question.
Yes, sir. Thank you very much, sir.
Next.
Yes, Vartika, you can.
Good afternoon, sir. So actually what Swarnlata is saying, I'm just extending her point here. That was my point exactly. So I feel, when we are talking about joint custody, parent alienation, and when we are saying that the welfare of the child should be paramount, I feel where there is a case of domestic violence. So even during this visitation, that there can be this continuing domestic violence even in that case. So is it actually wise to separate the legal right of parent, let's say in this case mother, or saying giving only primacy to the child's welfare? I feel somewhere these are too integrated, the welfare of mother as well as the child when they are together.
You see, you're right. Now, if apparently there is domestic violence, you cannot subject the child to witnessing domestic violence. 1. 2. The father may be very violent towards the mother, but the father may be very loving to the child. But at the same time, it is not good psychologically for the child to be exposed to incidents of domestic violence. Now, I may also share with you that in 5 times out of 10 or 7 times out of 10, allegations of domestic violence are only trumped up. They are not established. They are used to take away custody. They are used to deprive the other parent of custody. So, if they are not found to be correct, now let me narrate to you an instance of a matter which I dealt for 3 long years in the courts in Delhi before the family went back to the US. Now, this was a dispute between a couple, a North Indian couple who had married in the US, belonged to, they were Hindus by religion, both American nationals, one child born in the US, one child born in India. And the mother refused to go back, saying that I am exposed to domestic violence. I am exposed to very severe attacks and whatnots. So she filed a guardian and what's that petition? The man filed a habeas corpus. Both got decided on merits, and the court came to the conclusion on the basis of evidence that she has said domestic violence, but there is no evidence. She can't prove it. But all the same, the children were very small. Now the question was, what do you do? So the court said, all right, the woman will go back with the children. Now the court asked me to do something which is alien to the concept in Indian law, but which is very common abroad, is mirror orders. Now, what is a mirror order? When an order from one jurisdiction is made a part of a law in another jurisdiction, as it is reflected in that jurisdiction, it's mirrored. So the Delhi High Court told me, now we are giving protections to this woman. She will live alone. You will supply her finances. You will not seek custody of the children till the court in US decides. You will not separate the mother and the children. So I said, all right, I'll comply with all this. The court said, no. You go to US and you make this order a part of the US court order. So I went back to the US. The custody order which the court had made, I got it modified and I brought it back. So it was mirrored. It was challenged in the Supreme Court, but the long and short of it is, ultimately the woman went back after 3 years. Now, this is a balance which the court struck. The court said, listen, she has not been able to establish domestic violence, but we are not going to separate such small children from her. 3 years old, one was 2 years old, one was 7 years old. They will remain in the custody of the mother, till the court in the US decides what is to be done. Father can visit them, but will not live with them. Father will have access to them, but will not take them away from the custody of the mother till the court decides visitation or whatever. So this is a balance which the court struck. So you have to, actually speaking, come out of domestic violence in a very organized way. The man said, my wife is bipolar. She doesn't know what she does. So his allegation to another allegation was sorted out. Now you read, I think the decision of the Supreme Court has come in the papers today, where a man is saying that my wife suffers from a serious psychiatric disorder and her refusal to go a medical evaluation amounts to cruelty and therefore I should be granted divorce. The High Court agreed with him, so family court didn't agree, High Court agreed. Now the Supreme Court says, no, we will have to go into it whether such an allegation unproved can be accepted as a ground for divorce. So you have to actually decide what is domestic violence, proved or not proved. If it is proved, you have to make an exception. You cannot give custody of a child to a parent who is abusing the spouse. That's very clear. And it is an exception in the Hague Convention also, that the child may also be exposed to domestic violence. So this is something which is on a case-to-case basis perception. You can't lay down a hard and fast rule. You can't say this is the rule. See, family relationships are always very flexible. So you have to iron out the creases the way you look at them. Ma'am, there should be more questions. There no more.
Yes, ma'am. So just a follow-up, sir, but still, when you were explaining that for the family court, there lots of judge discretion is there. They can override the procedures also. So I feel, there are lots of gray areas where the situation, especially in the case of NRI wife abandoning cases, these situations can be exploited in favor of a party which is having, deeper pockets. In that case, whoever it is, one party or another. And most of the times I have seen that custody is used as a tool, to negotiate the alimony amount also, where the children are playing as a tool.
No, what you are saying is 9 times out of 10. The child is not an issue. Alimony is the issue. In a matter which I did, the child was more of a bargaining tool for negotiating heavy amounts. I remember a case from South Africa where the man was fabulously rich and the lady came to visit her mother with a newborn child, and all of a sudden there was domestic violence, there was 125 CRPC, one custody case, and the bottom line was the woman said, I want money. And it amounted to millions of rupees, and the bargaining chip was custody. So this is a very sad story. I did a case in Australia where a woman walked out and obtained an order of, you can obtain an order of temporary custody under the Domestic Violence Act also. So the man went to the Australian court and said, this is not final. So I was put a query whether a domestic violence case custody order amounts to a final decision by a custody order. I said, no, it's not. But what was the bottom line? Unfortunately, children are used as bargaining chips to settle scores of matrimony or for exchange of alimony. Sometimes people say, all right, I don't want it. And then there is a regret. So this has led to very serious misuse. You see, we have the Prevention of Women from Domestic Violence Act. We have 125 CRPC. We have 406, 498A. We have anti-injunction suits. We have Guardian and Wards Act proceedings. We have Hindu Marriage Act proceedings. A woman can take out 6 different proceedings and tell a man, if you step on India, I'll have you arrested. So I need what you have to give me. So our laws are all actually imbalanced. And they go to different courts. That's the worst. You can't even club them. Should a domestic violence petition go before a magistrate or the family court? This is a question pending before the Supreme Court. So you are rubbed in every jurisdiction wherever you go. And if you want transfer of the petition, Supreme Court says no, then it's worse. So you have different courts in different jurisdictions doing different things. We actually need to reorganize our family law structure, the courts, the hearings. It's a gray area. It will take time. We haven't moved on, We have a large influx of a population from abroad, 30 million people living in 200 countries who bring in all kinds of new things. But we haven't changed. We don't recognize the irretrievable breakdown of marriage as a ground for divorce. We need to. So we have mutual consent as an apology. But then that's the only way out.
Thank you, sir.
Any other thought process?
So I have a question.
Yeah, sure. Fire away.
Yes, so in the meantime, when the decision has not been brought up in the custody case, then where the children will, is there any procedure decided by court that where the children will live till any decision is made by the court in the meantime?
See, I read out to you that under Section 12 of the Guardian and Wards Act, when you file a petition under Section 7 and 8, under Section 12, you can move a miscellaneous application for an interim arrangement. So under Section 12 is the power of the court to make interlocutory orders. Interlocutory orders are orders during the pendency of the petition. So till the case is decided, when you file your petition, you say, this is my petition for permanent custody, permanent guardianship, and this is my petition for temporary arrangement. So the court is obliged to make a temporary arrangement of custody depending on the facts of the case. Ideally speaking, one parent gets custody, the other parent gets access, visitation, or weekend rights. So the ideal way to do it is ask the court that till you decide the matter, till the matter gets concluded, please make the application on interim custody a decision, and then we can move on.
Okay, sir.
Any more questions?
What's for lunch is the next question.
I think that's also one of the reasons why they won't be asking questions.
They all want to go to, they all want to run to their tables, not to the mess.
Yes. But sir, I think I'll just ask one
Yeah,
question, which so when we talk about the ideas of shared parenting coming up in the Indian context as well, and also keeping in mind that if when I have read most of the judgments, the bottom line has always been the welfare of the child. So, but in cases of shared parenting, when the judicial focus is on the idea of fairness, of how it should be fair for both the parents to have access to the child, aren't we again? It's also very complex, because what we are trying to do is we are not looking at the psyche of the child, in the sense that the child will again be extremely divided. So are we also looking at the emotional needs of the child? Maybe the child feels that this fairness standard is being imposed on the child. So in those situations, how will we look at welfare of the child principle in contrast with the shared parenting?
See, the idea of shared parenting is not rights of parties. It's balancing the welfare of the child. Now, how is this balance to be achieved? Now, I have seen very, very grim cases in the lockdown. The mother refuses to let the child come on phone. The man is waiting outside the house or the building or the flat. The mother refuses. Do what you like. And the bottom line is, I want to get even with you.
Hmm.
And the child, whenever the child gets access, he says, "Oh, well, I've got used to this kind of lifestyle. Don't worry, I'm fine. I can manage." Some children reflect a lot of maturity. Now, see, this is a very difficult situation on how you have to balance everything. You have to, the judge has to be a very wise person. He has to balance the rights. Uh, I had a very senior police officer and a law professor fighting over their child, and the police officer was having a gala time with another police officer, and his wife was thrown out of the house. So she came to the High Court in a habeas corpus. High Court said you have to file a guardianship petition. So the ultimate arrangement was Monday to Friday, child goes to father, the child goes to mother, and Saturday, Sunday, child goes to father. And the child was very happy with both the parents, because they both spent a lot of energy and a lot of time on him. They were very bad to each other, but they were very good to him. This is what happens in most of the cases. See, I had a matter recently where the guardian judge balanced it out by saying weekends with the father, holidays, 7, 8 days with the father, otherwise mother. Mother refused. She challenged that limited order also. So there I told the judge she has to let go. So I said, you give me weekend visits. The mother says the child can't sleep without me. So I told the judge, all right, I will pick him up on Sunday morning and I will return him on Sunday evening. How can she have an objection to that? So, and the child says, yes, I'm fine with that. And when the child, I told the man, I said, listen, if you have him for the night, he's going to sleep. But if you get him on a Monday, see, the distance was very short. Ambala to Yamunanagar, 40 minutes. I said, listen, if you get him in the morning at 7 o'clock or 8 o'clock and you return him at 8 o'clock, at night he's going to go back exhausted, and let the mother stick to him and sleep with him. So what? And the boy has a delightful time going back to his dada, dadi and his cousins there. So I think children adapt, and when parents show affection, children look forward to it. But there's a bad side to it also. You see, the father is Santa Claus, showering gifts, present, expensive things. Spoils the child. It ruins him mentally also. You, you know, somebody who's keeping the child for 5 days or 6 days a week, how much can the person spend on him, and how much can the person spoil a child? You have to discipline him, you have to educate him, he has to go to school. It screws you up, it damages you very badly, and there is a lot of polarization also. Let me give you a very extreme instance. I did my first child abduction matter in 1986. This was a case of a Jat Sikh lady, British, totally born in England, married a guy from a weird village somewhere in Punjab, brought him to England. They fought. This guy picked up the kid and brought him to the village. He left him in the village and went away. So she came with a foreign court order. We went to the village. We couldn't find the man. So ultimately, a lawyer paid for him, and by the time we got to the child, he vanished. So the woman never found the boy. Ultimately, she found him after 6-7 years in the US. The High Court gave me a roving writ. Whenever he comes to Punjab, you can arrest him.
Okay.
So ultimately, she got him. She reared him up. Now the boy is 25, 26 plus. He's got married. Now, when he was to get married, he didn't call his mother. He became so independent. And he tells his mother, you separated me from my father. I can never forgive you. She was the one who reared him up. She was the one who brought him up. She was the one who put everything together. She says, I want to bond with my father. So this is the effect of parental alienation. That blood boils and, child goes back to his father. So these are extreme ends. You see, splitting up children is not a good idea. Children from single parents, broken homes, unfortunately, always wind up somewhere going wrong. It's not a rule, it's sad, but it doesn't work well. So whatever you may do, some negativity will remain somewhere. You see, what a father can do, you should read Justice Reena Nag's mother. I did a family court matter before Reena Nag, a family court judge in Delhi. I'll send you the judgment. Read her judgment. It's a beautiful judgment, family court judgment. She says the father has a different contribution, the mother has a different contribution. Either can't replace the other.
Correct.
Though you have people like Karan Johar, you have people like Sushmita Sen. They are single parents. Tushar Kapoor. These are people who have brought up children singularly. I don't know what kind of children they're going to have, but there is a concept. Adoption, surrogacy. You don't want a marriage. You just want the children. See,
These are evolving ideas, I understand, and I think the entire jurisprudence has been evolving that way.
Yeah, sure. And it's beautiful talking about it. I like your interest in family law, because normally the person who's conducting these sessions is saying hello, thank you, and goodbye.
Thank you so much, sir.
Are you teaching family law?
Yes, sir. I'm teaching family law in all these 3 batches.
So
And all 7 of them.
now you get to the director, tell Gurpur ma'am that Mr. Malhotra wants to visit physically and he has refused all online lectures now.
Oh, sure, sir. I will pass your message.
Let us look at live-in. Let us look at relationships outside marriage. Let us look at surrogacy, and let's organize 2-3 lectures physically. Now things are opening up. Let's have a physical lecture session in Pune.
Absolutely, sir. In fact, those are the issues I'm currently focusing in the LLM batch as well.
Oh, yeah, sure. Or no open house. Open the lecture for all the students. We can do 2-3 lectures in a weekend.
Perfect.
For Monday.
Perfect, sir.
Plan, get into action.
Yes, absolutely. I will. And I will keep you in touch as well.
Yeah, till the lectures are planned, all other lectures online are on hold. Superior capacity to blackmail.
Correct.
Chalo. Nice. Anybody else? Anybody
Any
else
more questions?
Anybody else who has been provoked, ignited? Don't hesitate. Doesn't matter. Even if the question is absurd, no problem.
So I want to thank you that I understood many prospects that I didn't listen before. So thank you.
Wonderful. So you write to the director saying, I want him to come physically because I have a lot of questions.
Yes,
I actually want to come to Pune because
yes, I'm already typing this mail, sir. Thank you, sir.
get about 100 students to sign it also.
Yes, Vartika, you want to say something?
Yes, sir. Sir, sorry, I'm again what you were discussing with ma'am. Sir, you know what you were saying. This all is having one essential element that the parent, be it father or mother, they are honestly they want to be involved in the parenthood. But what in the case that they do not want to be involved per se? But again, like for the cases of alimony or the deal, their presence is there. So in that case, the shared parenting will be a big failure. In fact, playing with the emotion of the child.
See, I'll give you a case. ABC versus State. This was a very affluent couple where the woman fathered a child outside marriage.
Is it the Christian woman case, sir?
Yeah. So
Yeah.
now the woman says, I want a single parent certificate, birth certificate. So the registrar said, get lost. So it reached Supreme Court, and Justice Vikramji Sen says, if the father, she knows who the father is, he doesn't want to be involved. Why should we bother him? So there came the concept of single parent birth certificates. Now this happens in surrogacy also. The natural mother is the commissioning mother, not the mother who gives birth. So if there is a parent who doesn't want to be involved, you can't force him to be involved. If a person says, here is the money, take it or leave it, I don't want to do anything with you. That's what it is. So in such circumstances, forcing or pushing a parenting plan on a non-interested parent doesn't make a difference. But at the same time, I remember I was assisting the High Court in a habeas corpus where the mother and the father were so fiercely and bitter. I took 15 attempts to sort out the matter, but they refused to come on a common platform. So the judge said, listen, you know what I'm doing? I'm sending the child to a hostel. I'm not giving custody to either of you. Both of you can spend money on him and visit him in the hostel when he wants to meet you. And you can say goodbye to him and hello to him there only. So you have to, I think you have to accost a non-involved or an over-involved parent with an extreme situation. Say, this is what I'm going to do. Whenever you want a logical answer, you have to take an argument to two extremes and then come to a proper rational basis. So if a father says, I don't want anything to do with the woman, this was a one night stand, or this is something I don't want to be involved with, I don't love the woman, and so on and so forth, then it's goodbye. Well, single parents are known to have brought up children very well. Sometimes I see children very normal and balanced, and it's very strange to find that they're brought up by single parents, and it's very rude to tell a parent, oh, you've done very well. No, it's not a good idea. It's as you say, it might be very sarcastic. So it's best to keep your mouth closed when you see such a situation and not criticize it either, or ask a lady, where is the father? It's best not to ask him polite questions. This is a very private area. You cannot ask. I mean, there was a very enlightened judge in our court from Delhi, brilliant man. He's in Odisha now. Excellent couple. Wife was in education. There's no children. And some judges would go to him and ask him, where are your children? It was a stupid question. Everybody knew I had no children. But then you should not ask awkward questions.
Okay,
Yes,
sir. Thank you.
yes, I guess this maturity comes, this wisdom comes with age and asking wrong questions a number of times. So you have a brilliant family law teacher who has just joined, and the new ones always do better than the old ones.
Thank you so much, sir.
Wonderful.
Uh,
Excellent interacting.
as Sir, it has been a pleasure to be, enlightened by a person of your likes, and I can definitely vouch for myself. But also, I'm very sure that the takeaway for students from your lectures must have been insightful as well. And the fact that you focused on how the entire child welfare principle and the entire family law jurisprudence in general has evolved over time, and the fact that you threw light on the most recent case laws also shows us how much expertise you exercise in this sphere of law.
Oh
So
no,
personally,
this is bread and butter. I have to read to keep alive.
yes, sir, but then not everyone does that. So,
The passion.
personally, I happen to gain a lot of insights from your lectures today for my future family law classes. So, I would like to extend my heartfelt gratitude.
You should get hold of my book, Global
Yes,
India.
absolutely.
You should order it in the library because it is in 7 parts. It is
Okay.
900 pages and it's the best of best. Every part is numbered. I'll send you the breakup of chapters. What you do, you send me your address. I will sign a copy and send it to you.
Oh, that's wonderful, sir. Thank you so much.
Well, you
Thank
belong to
you so
Haryana, so you deserve a special treatment.
And that's the identity connection we have.
Absolutely.
Yes.
Absolutely.
And also on behalf of Symbiosis family as well, we look forward to having you again soon, sir, as
Please,
it has always been a positive experience
and
with you.
please pass on my request to Gurpur ma'am that I want to taste Kiani. Have you been to Kiani Bakery biscuit? And I had to
I've been there, but yes,
please
you
tell her
should.
that I need to visit all the temples again and I need to go to Kiani Bakery.
Absolutely, sir.
Please
Thank you
organize.
so much.
All the best. Bye.
Bye bye, sir. Thank you so much.
Bye. Bye.